What is litigation? Start again. You rolled it without while you. Can we start that again? What is litigation? When people hear the word litigation, they often think of dramatic courtroom scenes where one party is found guilty. But in reality, litigation simply means taking a dispute to court for resolution. It's a formal process where one party, the plaintiff, brings a case against another, the defendant. You will usually see litigation in civil or commercial disputes, things like breach of contract, shareholder disputes, recovery of unpaid loans, to name just a few such actions. A judge, having heard both sides, will review the evidence which was presented to him or her along with the law and then makes a binding decision. That decision, called a judgment, can sometimes be appealed. The decision, once published, will be part of the public record and may even shape how future cases are decided. The process can be complex, technical, and at times expensive, but when managed by experienced lawyers, litigation can be a powerful tool for enforcing your rights and recovering any loss. But court isn't the only way to resolve disputes. There is another approach that's potentially faster, private, and often more commercial. This process is called arbitration. So what then is arbitration? Arbitration is a form of alternative dispute resolution. It enables parties to resolve disputes privately outside of court. Instead of a judge, the case is heard by an arbitrator or sometimes a panel of arbitrators. Typically, people who have expertise in the area of law or particular area of law or industry involved. The process is confidential, more flexible, and the parties are not bound by the strict rules of court. This said, it still involves presenting evidence and arguments because it's not based on strict court rules and can be timetabled without the caseload burden of some courts. Arbitration is often generally faster and can be more cost effective than going through the courts. At the end, the arbitrator delivers a binding decision which can be enforced through the courts if needed. However, and this is important, arbitral awards usually can't be appealed. In Australia, arbitration is particularly common in the construction industries, infrastructure disputes, investment disputes. It's also highly effective in cross-border disputes or when one party is an overseas national or an overseas party. Because arbitral awards made overseas can be recognised and enforced by Australian courts and vice versa, this proves to be a particularly strong dispute resolution mechanism in international contracts. So, which one should you choose? The choice between litigation and arbitration really depends on your goal. If arbitration, while you can agree to arbitration rather than court litigation after the transaction contracts have been signed, it's usually best to have agreed to arbitration at the outset of the contract. That is because arbitration requires the agreement of all sides. If you want public accountability and the possibility of appeal, litigation might be the better path. If on the other hand you value confidentiality, efficiency, flexibility, arbitration can save time and cost. For businesses operating internationally or in industries where relationships matter, arbitration offers a discreet, commercial way to resolve disputes while protecting reputation. At the end of the day, both are powerful methods of dispute resolution. And at Ironbridge Legal, we help clients decide which strategy is best to protect their interests and support their commercial objectives. I'm Trevor Withane. Thank you very much for watching this video.